Okay. So, very good evening, everyone. I am CA Ruchi Chawla, moderator of this webinar. We are delighted to welcome you all in the webinar being organized by CCLEA and NPO Committee of ICAI. It is my pleasure to be moderator in Know Your Law Series 42 webinar or contract drafting and negotiation best practices, a practical guide on 28 December 2023 from 4 p.m. to 6 p.m. Being organized by Committee on Commercial Laws, Economic Advisory and NPO Cooperative of ICAI. In a short while, we will start this webinar. I would like to apprise you about CCLEA and NPO committee. This committee is focused to encourage chartered accountants to shape strategy and policy that unlock economic, financial, and social values while combining analytical foresight with commercial acumen. One of the core areas of this committee is to serve the multifunctional task of analysis, knowledge dissemination, input to regulators on policy formulation, to develop and publish technical guidance, background materials, etc., and to create awareness for professional opportunities for chartered accountants in commercial laws, economic advisory, and NPO cooperatives. Our eminent speaker will talk on contract drafting and negotiation best practices, a practical guide in this webinar. We hope that the same shall be useful to the members. Now, I would like to introduce you all with our speaker. CA Ramesh Prabhu sir, BCom FCA CISA. CA Ramesh Prabhu sir is a practicing chartered accountant and CISA qualified with experience of more than 3 decades and whose opinion is sought on various laws and issues, particularly in RERA and cooperative sector. He is partner in RS Prabhu and Associates Chartered Accountant Firm, chairman of Maharashtra Society Welfare Association, a Mumbai-based registered NGO which is spreading the cooperative society movement across Maharashtra, and chairman of Swagat Housing Finance Company Limited. He is regular faculty and task force member with Institute of Chartered Accountants of India. He has addressed number of seminars and webinars organized by WIRC, ICI government department, newspapers, political parties, NGOs, etc. He is the co-opted member of Cooperative Committee for Maharashtra by WIRC of ICI for last few years. He has practical, in-depth knowledge of the cooperative and housing sector. He is the author of 40 books on issues like conveyance, transfer of flats, parking, collection of dues for members, and service tax for housing societies. He has authored 4 books on RERA covering all important features thereof. He is the editor of WIRC Maharera Practical Manual to be published by WIRC of ICI. He is the editor of MSWA Housing Societies Review, having a circulation of 35,000 copies with readership over 1.5 lakhs across Maharashtra state. He is appointed by Government of Maharashtra in 2008 on its committee for drafting the law for deemed conveyance. He was invited to discuss before the Parliament or Committee of Government of India to discuss draft bill of RERA, and most of his suggestions were incorporated in final approval of the said act. His book on deemed conveyance was released by Sri Prithviraj Chavan, ex-Chief Minister, Government of Maharashtra, with a forward message from Her Excellency Srimati Pratibha Bhai Patil and then the President of India. And C. Ramesh Prabhu sir has occasion to be presidential guest at Rashtrapati Bhavan, New Delhi. He is the member of the Committee of Government of Maharashtra to include a separate chapter for Cooperative Housing Society in MCS Act 1960. MCS rules, election rules, and bylaws. He has become synonymous with housing society redevelopment and RERA matters in Maharashtra. He has authored book on self-redevelopment released by the Shri Uddhav Thackeray, CM of Maharashtra in February 2020. Now, I would like to hand over the mic to to our speaker, and question and answer session will be in the end. Over to you, sir. Sir, unmute yourself, please. Sir, unmute yourself.
Yeah. Good afternoon, friends. Thank you very much, Ruchi Chawla and all the technical team and ICI for giving me this opportunity to interact with you and share my practical, in-depth, or whatever the knowledge that I have gained over the last 33 years in the Contract Act and the negotiation skill that need to be done and the practical aspect of it. Of course, as the time permits, we'll certainly look into the Contract Act and try to look at the various sections which may be relevant. Now, let us try to understand without getting into the PPTs and other aspects. Let us try to understand what exactly is the contract. Contract is normally between two parties. The one party who proposes, another party who accepts. And naturally, the contract happens. Now, when we talk about contract, each contract has to be enforceable. If the contract is not enforceable, it has no meaning. So when we talk about Contract Act 1872, it has various terms and conditions, various provisions which need to be looked into. So therefore, when we do any contract, that has to be, it is nothing but a contract between two parties or agreement between the two parties, but naturally it has to be enforceable. If the contract is between two persons, let us say a contract between father and son, that's to get some milk or get something else, those contracts may not be enforceable because that is not without consideration. And again, even if there is a consideration, it is out of love and affection, or which is not in return, and it is not enforceable by law. However, when we look at the contract, the subject matter that we are going to deal with today is the various aspects to be looked into in a contract. First and foremost, what is the subject matter of the contract? Let us say the contract can be for movable property, it could be immovable property. Contract could be for providing a services. A contract could be giving certain intangible, goodwill and other things. So therefore, contract can be various types of contract. And if I'm looking at, let us assume for a minute, I'm talking about a contract for a movable property. If it's a contract for a movable property, then naturally it happens. The contract, whether it is a current contract or whether it is a future contract. If it's a current contract, within what time the goods need to be delivered, whom it has to be delivered, what will be the price of the goods, what are the quantity, then what are the characteristics of the goods that I have to supply, then how the checking of the quality will happen, and within what period the consideration will be paid, what is the credit period. See, all these types of, the terms and conditions are getting recorded in a contract. Now, naturally, any contract, as I said, the most important is we have to look at who are the parties involved. A contract may have involved two or more parties also. It is not necessarily that the contract will have only one party. Contract has to be between minimum two parties, and it can have a multiple parties. Now, when I'm talking about a multiple parties, because there can be a supplier, there can be a purchaser, and there can be a facilitator, there can be a bank which is giving a loan, there can be an agent, there can be a middleman. So this way, the contract can have minimum two or more parties. Now we have to identify when we draft a contract, because now it is a drafting skill. Now when we draft a contract, first and foremost, as a chartered accountant or a practitioner, what we need to do is we have to look at the parties who can be made, applicable in that particular contract. So when we talk about applicability, naturally the connected parties. Now, why we want connected parties in any contract? When we have a parties, each party's obligation also should be looked into. If there is a contract and there is no obligation or the duties cast on the parties, then it is of no use having those parties as the parties to the contract. So first of all, we have to understand the parties who can be involved in the contract. Having decided in a practical aspect that who are the parties in a contract, now the second comes, will that contract be naturally oral or writing? A contract can be oral contract. But today in the session, we are not talking about oral contract. Even if there is a oral contract, I would certainly say, as a prudent practice, that should be recorded in the form of email. Because what happens is, you may deal with somebody saying that, okay, we have agreed to purchase so and so goods, and he says, I will sell. And then later on, you must have agreed for a particular price. But then he delivers and he gives the bill of a different amount. Then at no point of time, you have already received the goods, you have used the goods, and after 8 days, 10 days, you get a bill which is exorbitant. What he promised was at X price with a certain percentage of discount, whereas he has not given the discount, or he has not given the agreed discount. These are a oral contract, but the goods have been issued, delivery challans are there, and then you cannot say that, no, it is not acceptable to me. So therefore, even if there is a oral contract, I would suggest that it is always better to get it recorded. So therefore, we are talking about a contract which will have a legal enforceability. And therefore, how can we get recorded? Naturally, each of the conversation that we have, either on the phone or the WhatsApp or on the messaging or a physical discussion that we have, better and the best practice is to have it recorded. I will give you some examples, because when we talk about a practical aspect, naturally we need to give you some examples. I am mostly dealing with the RERA. I am dealing with the housing societies. I am dealing with the various communication that happens. And of course, in the redevelopment agreement, the contract, agreement for sale, release deed, power of attorney, so many documentation that we do, draft, and we also get it registered. So what I have seen in the RERA, when I'm doing a complaints against the promoter on behalf of the allottees, I have seen that the allottees make a statement that such and such thing was promised, and such things were, he was supposed to give me a delivery on so and so date. But when we ask for evidence, they say it is all oral, because the salesman talked to us, discussed with us. To the extent when we ask them, so do we have a brochure? They said, yes, there is a brochure. But do we have those brochures which are communicated by the promoter? They say, no, this was given to us. Then we also ask, have you signed any application form? They said, yes, we have signed the application. Do you have a copy of that? We don't have a copy of the signed application. Now, what happens with all this? Now, with all these, loose ends, when the client comes to you and we want to enforce our right, we want to enforce our, what you call, the entire, our rights on the particular property or particular transaction, and we want to go to the, appropriate court, then we are not able to go. Why? Because there are no evidences. Of course, even if there are no evidences, that does not mean that you cannot go. Certainly you can go. The question arises, even if you have to go, certainly go there, there has to be certain documentary evidences. So therefore, any contract, as I said, it has to have an enforceable value. In order to have an enforceable value, it is always better to have in writing. And if there is a oral contract, it is better to get recorded in the form of emails, in the form of minutes of the meeting, and get it served on the other party and ask their confirmation within specific time frame, that you please reply, you confirm what we have agreed upon. And if you don't reply and if you don't confirm, it is understood that you have confirmed on that. And similarly, this, trailing email, and once you get the goods, or once you have discharged your obligation, or they have discharged their obligation, it is always advisable, as I said, better to get it recorded. So sometimes what we do, if there is no evidence for the contract that we have executed, naturally we create an affidavit, because at the end of the day, the affidavit is also given on the oath before the notary or before the magistrate, is considered as a evidence under the Evidence Act 1872. So if it is considered as a evidence, naturally when we are filing a complaint or when we are going before any authority, it is equally important that we create an affidavit to the fact what we are narrating. Because sometimes the oral contract does not have anything written. But when we go before the authority, whatever we are saying is true and correct, and we are giving on the oath, and that is duly notarized or before the magistrate, and if it is filed before the uh, authorities or the court, then they can consider. Of course, the other side may always reject it, refute it, or they may say that they can deny it. But even after denying, the courts can consider this as one of the evidences. So therefore, first, when we do a contract, it is always better to have it in writing. And when we are having in writing, we need to understand the parties involved that I have discussed. The next comes, what is the subject matter? See, in any contract, when we talk about subject matter, so the subject matter is also equally important in a contract, because we are talking about drafting a contract. So the subject matter, let us assume for a minute, I am buying to buy a land, agriculture land. Then the details of the agriculture land has to be in detail. Because if there is no detail of the land which is going to be delivered, what is the area of the land, who was the owner of the land, who is presently owning, what is the status of the person who is selling, what is the status of the person who is buying, the subject matter is very, very important. It has to have complete detail of the land. Is it an agriculture land? Is it has any encumbrance on that subject? That means the land, whether there was a loan taken and within what period it has to be paid, what is the area of the land. So whether it is having a zone where the development rights are possible, or it has to be continued as a farmland. Is there any reservation? So all the plus and minus of that land and the characteristics of the land. I'm just on the subject of matter. Let us say land. If it is related to a goodwill, naturally, how long is the goodwill? What is the goodwill? How the goodwill has been generated? What is the valuation method which has been adopted? So all that will come, and which business you are going to deal, or which. So this is about a goodwill. If we are talking about, let us say, machinery, the machinery, what is the make of the machinery? Who is the manufacturer? When it is acquired? And is it a new make? What are the ancillaries that you are give? So the subject matter of the contract is also equally important. Now, as we draft, the collection of the information is also equally important. So having said that, the parties are identified. We have identified the contract, the subject matter of the contract. It could be, as I said, movable, immovable. If it is a immovable, movable, all that description will come. Having finished the second part, the third part comes the obligations. Because one of the obligations of one party becomes the duty or the rights of the other party. In any contract, as I said, it has to have an enforceable character. If it has to have an enforceable character, naturally, and without saying further, it has to have the obligation created between the parties, and obligation of one party becomes the rights of the other party, or duties of one party becomes the rights of the other party. So therefore, if I'm a vendor of a land, let us say agriculture land, and there are certain encumbrances, there are certain legal disputes, there are certain clearance that has to be done. Then as a vendor, I may agree that, okay, I'll get the encumbrances cleared within a certain time frame. I will be clearing the zone or the characteristics of that. Now it is agriculture, I will get it conversion into non-agricultural. It is a developmental. If there is a reservation, I will get it reservation lifted. If there is a legal dispute, yes, it becomes my responsibility to remove that legal dispute within a time-bound manner. So this way, the obligations, that is the duties which is cast on the vendor, will be recorded. Now, having said that, these are the duties of the vendor, and in any contract, a drafting skill, very important, that if at all we are saying these are the duties that is to be done, naturally, it has to have a time being essence of the contract, within what period it will be done. If that particular period is not being completed, naturally there will be issues. And that is how the contract can be terminated, or where your rights are getting, it becomes crystallized. Otherwise, if I say, the vendor says, it is my duty to clear the encumbrance, but the time frame within which the encumbrance will be cleared is not written. That means it's very simple. That means next 100 years also he will not clear the encumbrances, and he has already issued the money. So this type of open, keeping the terms and time open has no meaning. So therefore, having said that certain obligations are there, who has to complete that obligation? What are the obligations? Who has to do that obligation? Who has to complete that duties? The next is very important, time frame. So the time frame is also equally important. Without time frame, nothing works. Now, in many of the contract, the other side always would like to, keep certain leverage. In the sense, when I say leverage, they want to see that if they don't comply with certain things, we should not be able to terminate them. We should not be able to claim damages. So such leverages, if they want, then there has to be certain negotiation. That is the art of negotiation. Because any contract, when we talk about written contract or an agreement, it does not get finalized in one sitting or two sitting. Because every party looks at from their specs. They look at from their perspective, and whatever is suitable to them, they would try to incorporate in the agreement. And then we, as the receiving party, beneficiary, or representing on the other side, also would like to get our clauses incorporated. So it is always to and fro. And therefore, in any contract, when we are finalizing, the negotiation and the thought process and the reason for putting those clauses also equally important. So, parties involved. Second, subject matter of the contract. And third, when I'm talking about, is about the obligations of the party first. We can call it as a vendor, for example. And having said that, the obligations of the vendor, then if the obligations are not done, naturally there has to be right created on the other side. So vendor, this side, the other side is a, let us say, purchaser of an agriculture land. The purchaser will be in a position to implement or execute or implement this agreement. This contract, he should have an enforceable right. That means these are the rights created to him. Now, when these rights are created, naturally, either party, I'll come to the other side's obligation also in a drafting scheme. But let us, right now, we are discussing about the obligations, duties of the first party, that is vendor, in our example. So if the vendor does not comply, naturally, he wanted certain leverage, we can give leverage. At the discretion of the purchaser, the additional time may be given. That means now the purchaser keeps a certain yardstick with him, certain leverage with him, so that if at all he was supposed to clear the encumbrance within 6 months, but if the purchaser wants to give him another 3 months, at the liberty of the purchaser, he may be given another 3 months to clear the encumbrances or clear certain, disputes in the land, or to convert from agriculture to non-agriculture. So the purchaser can keep this leverage, and then by way of exchange of the communication, he can further extend. Now what happens? Suppose he does not do even extended period, and even after the leverage, naturally the purchaser gets certain rights. Now these rights, because he has not done, the purchaser gets certain rights. Now these rights has to be documented. What will be the corresponding right of the purchaser or the second party? If the first party fails to perform certain obligations which is agreed upon in a time-bound manner and regarding certain terms and conditions, And if it is not done, even after the extended period, at the discretion of the party of the second part, now the party of the second part should get certain rights. What will be the rights? The rights needs to be described very well. That means now the purchaser or the second party will have a right to claim for the damages. He will have the right to ask for certain interest on the payment made. He may ask for the compensation, okay, or the incremental value, or whatever may be the things, liquidated damages. All these need to be recorded. So in case of default of each of the obligations and the time frame is not completed, what are the action that the other side can take? What are the damages or the compensation that they will get? What is the interest they will get on the money? Within what period the amount will be refunded? So all these things need to be recorded nicely in your agreement. If that contract does not have these clauses, then it becomes arbitrary. It becomes not binding, because you have said certain things to be done within the time. If the purchaser or the other side wants to do certain action, but what action he can do, what will be the remedy for him, nothing is mentioned. Now the next thing comes, as I said, in a contract. Now we have crystallized certain terms and conditions. Now there is a breach of the terms and condition. The breach of the terms and condition can also be mitigated. It can be removed. How it can be mitigated, how it can be removed, all that need to be clear cut written in the document. Now, even after having option of mitigation, the customer does not do it, or the other side does not perform, or one of the parties does not perform the contract. Naturally, in the contract, we can always have a clause, what will be the dispute redressal mechanism. See, the contract has to be in a systematic way, and therefore, you need to have what will be the mitigating, how the dispute will be resolved. The dispute can be resolved under various, systems. Now, just to give you an example, it all depends on who is the party and who is going to implement or who wants to enforce the contract. Suppose I am a consumer, I am a flat buyer, and from purchase I have gone from the developer. Now, naturally, if nothing is mentioned in the contract, then if it is under construction property and it is a recent provision, then the applicable law is the RERA. So the first thing is whether the project is registered with RERA or not. If it is not registered with RERA, then I will not be able to go to RERA. Then I will have to go to some other remedies which we'll discuss. But remedy, the moment I am talking about enforceable, as a drafting person, I need to understand what is the remedy that is available to either parties if there is a breach of the terms and condition. So the remedy would be, one, the applicable law under which the contract is made. Second, having said that applicable laws we are looking into, I will just give you some more examples as I proceed further. But just to give you overview, is that once I understand that this is the applicable law, naturally under that applicable law, under which that contract is being made, then what is the remedy available? Is there a system which is available? Otherwise also, it is possible that contract is being a civil nature. Naturally, civil court is one of the options available. But if I'm a consumer, I'm also getting additional remedy. Under the Consumer Protection Act 2019, I will be able to go under the Consumer Protection Act, get the additional remedies done. So if at all I'm a consumer. But if I'm not a consumer, because there is a contract between two traders, then they will have to go to the commercial court. There is a civil court that's called commercial court. We can go to the commercial court. But at the same time, a contract which is there, it also can, if it's a commercial contract, then we can also mention that we will go for something called mediation initially to start with. We can also say that if the mediation fails, we will go for arbitration under the Arbitration and Conciliation Act 1996. So who will appoint the arbitrator? Whether I will appoint one arbitrator as a vendor, another person as a purchaser will appoint another vendor arbitrator, and they will come together and appoint a third arbitrator. Or even in the case of arbitration, if there is a sole arbitrator, what is the process of appointing an arbitrator? What will be the language in which the arbitration proceedings will happen? Then what will be the character of those arbitrators? Who will pay the fees for the arbitrator? Where will be the place of the arbitration? Will it be in Mumbai? Will it be jurisdictional issues? So the jurisdiction also will be said. Okay, under which jurisdiction that particular contract will be enforced. So whether the jurisdiction will be Mumbai, whether the language will be in English or Marathi, Hindi, or it will be, how it will be done, whether sole arbitrator or three people tribunal, and how the expense will be borne in case of dispute, if it is arbitration. So therefore, the contract also should have a legal enforceable platform where we can resolve our disputes. If nothing is mentioned, the law of the land will prevail upon. Of course, they can always go to the city civil court and get the things done. But when we are doing, it is good to enter. Now, as we are moving further, it is also possible. A contract can be for within the country, or it can be international contract. If it is an international contract, naturally we look into various treaties which are available, which are the forum where the dispute will be resolved. Everything will be recorded because international arbitration is also one of the important things. So this way, the contract will have certain binding clauses which will be executed between the parties, which will be recorded nicely, and then the dispute recovery mechanism. Now, the contract, as I said in the beginning, if it is legally enforceable, there has to be some consideration, because that consideration is most important in any contract. And the consideration, if I'm selling agricultural land, the consideration can be either cash or it can be in kind. When I talk about cash, it is not monetary cash or currency that I'm talking about. When I say cash, that means a money transaction which is going to happen. It will be either by check or RTGS or any other mode of banking transaction or internet banking or credit card payment. But what will be the money which is consideration amount? And when we talk about a consideration, naturally, the consideration, whether it is a current consideration, whether it is a future consideration, what will be the time within which the consideration will be paid? The secondly, I said, the consideration also can be in kind. For example, I'm giving something called a development right. I'm a landowner, I'm giving a development right to a developer to construct the building. And in the contract, it is agreed that he will construct, let us say, out of 100 flats, 40 flats he will construct and give it to me, assuming that all the flats have the same value, or 40% of the total built-up area, which he is going to construct on my piece of land, he will give me 40% built-up area. Now, if he is giving a 40% built-up area, that means constructed area, which means, again, I'm entering into something called consideration in kind. So therefore, I have given a land, he is giving me in consideration in kind. So how that consideration will be given, when it will be given, what will be the various characteristics of those consideration, whatever the way we write. So consideration which is received in kind, if it is I'm getting some machinery, and as against machinery, I'm giving them a final product. That also is a consideration in kind. I have seen a lot of contracts, or I have drafted also some of the contracts where the author writes. He writes a storybook. He writes, academic books. He also writes various law books, and then he enters into a contract with the publisher. Now the publisher will agree to give sometime royalty, and sometimes they say that instead of royalty, we will give you, as and when we print, let us say 1,000 books, we will give you 10% of the books to you, so that you also will be able to market it in the public place or whatever book is there, we will sell, and the money comes as and when the money comes, we'll give you. Which means sometimes authors also need books to give on complimentary basis. So certain portion can be on cash, certain portion can be in kind. So even in the case of a development right, he may say that, okay, give me extra 40% development rights or built up area. What you do is you give me 20% built up area, remaining 20% you give me in the form of amount. So initially you give me so much money as a signing amount. Then as the work progresses, you give me additional money. So this way, a consideration can be current consideration, consideration can be future consideration, it can be in a certain manner. Now in the case, normally in Maharashtra, from where I am talking, there is a land, many are owned by RWA, that is called Housing Society. When they go for a redevelopment, when they go for a construction, they enter into a development agreement, a joint development agreement with the developer. And then they say that so much amount has to be given as a corpus to take care of hardship allowances. They should be given existing flat along with another 20% extra area. They should be given monthly rent compensation for the displacement till the new building is not ready. So these are the certain terms and conditions. These are all the consideration that has to be paid. As I was saying, when we talk about the subject matter of a development, the development is based on certain other prevailing law. Now, if it is talking about a development right, then it is got lot of applicable provisions. For example, in Maharashtra, we have Maharashtra Regional Town Planning Act, under which there is a planning authority. There's a development control and promotion regulations, which is giving you the permission for built up area. If it is a, let us say another UP, we have Country and Town Planning Act. So for the purpose of development, there is a Country and Town Planning Act. Based on that Country and Town Planning Act, there is a Nagar Nigam, and then there are other various authorities who concern. So there, this way, now in Maharashtra we have Maharashtra Housing and Area Development Act, which is then Maharashtra Regional Development Authority, MMRDA. So like this SRA, Slum Redevelopment Authority, various authorities are there depending on the land, depending on the development permissions, what type of development you are going to do, which is the law that is going to be applicable. And if it is a development right, what will be the obligation? Will you get RERA registered? How you will take care of the allottees? Whether the landowner has any obligation on the allottees, or if the project is completed, the landowner will convey the land. With another obligation on the landowner that he will convey it to the association allottees. So this way, the development agreement or any agreement will have certain terms. These are all through the negotiation. And let me tell you, when we are drafting an agreement, as I was again saying, we need to look at what are the applicable laws. If we do not understand the applicable provisions of the various law, then we will be doing injustice. Now, when I am talking about applicable law, let us assume for a minute development right itself, development agreement itself. The first and foremost is the Contract Act 1872. Of course, I will look into it. The second comes Development Control and Promotion Regulations. That is a Maharashtra Regional Town Planning, if it is Maharashtra. In other place, other areas. The third and very important thing comes. If this contract to have an enforceable, whether it has to be in writing, if it is a immoral property related, yes, it has to be in writing. That itself says under the Transfer of Property Act. Because what are the provisions under the Transfer of Property Act? That also I need to look into. If the land is earlier owned by, let us say, X, and he has expired, and the development right you are going to get is from the legal heirs. If that is getting from the legal heirs, naturally, whether there is a heirship certificate, that means you have to look at the succession law, whether they are a Muslim, whether they are a Hindu, what is a personal law applicable to them, whether there is a testamentary document which they have obtained, is there any court order, and the seller, if there is a minor, then I have to look at getting a court permission to get the consent of the minor. who is a guardian, whether that person has any right, whether, so this way, you need to look into the applicable law. So then the next question comes, if it is whether income tax is applicable, if it is an income tax applicable or not applicable, we'll see later. If the vendor is, let us say for a minute, is a NRI, naturally I need to retain certain portion, 20% of the sale proceeds, and I have to deduct TDS under section 195 of the Income Tax Act, and I have to remit. If it is more than 50 lakhs transaction, let us say any immoral property, then I have to deduct TDS of 1%. That is applicable under the Income Tax Act. So what is the income tax applicability over there? I also need to look into the what is the GST, whose obligation it is to pay the GST, how it will be discharged. So that means various connected law. I need to know. If it is a dispute resolution, then I have to look at, is it arbitration law applicable? Is it a civil law applicable? Am I required to go to the commercial court? Am I going to go to RERA? Or so what I'm trying to say is that when you are drafting, I need to apply my mind as a drafting person. It is not the Contract Act, it is not a Transfer of Property, it is not a Registration Act, it is not a Stamp Act. Stamp Act is also applicable. Registration Act is applicable. I need to look into what are the other laws, connected laws, ancillary laws that is applicable so that my contract becomes watertight. If there is a partnership, I'm just trying to explain. If the vendor is a partnership firm, the partner who had signed earlier and the partner who is now signing are going to be different, let us assume. So in that case, you also look into see whether that transfer, the person who is selling, whether it's a partnership which is registered. The unregistered partnership firm cannot be sued. If there is an unregistered partnership, let us say two brothers are coming, forming a partnership firm, and they are going to sell certain things to you. Tomorrow, if they don't deliver, you want to, you know that they are the two brothers, they are got a partnership deed, but that is not registered. If the partnership deed is not registered, at least in Maharashtra, I'm sure that it has to be a registered document, registered partnership deed, and it is applicable across India. So if it is not a registered firm with the register of firms, then I will not be able to enforce my rights. So therefore, what is the legal status of the person who is executing? So this is also equally important for us. There are certain AOPs who are, executing the contract. So what will be the status of the AOP? Is there an income tax return? Who are the AOP members? So as I said, partnership. If the partners have changed, is there a change of constitution? Whether every disputes have been resolved, or is it that somebody comes and just signs? So is there a resolution? If it is again a company, then is it a resolution is there for signing that document, executing that document? Whether he is a authorized person. If he is not authorized, how you will identify he is authorized? If it is a company, naturally I will look into the KYCs of the company. I will look into the firm. Is he a director or is authorized? What are his signatures? Whether there is a resolution to that effect. So these are certain things very important when we are drafting a contract. It can be both the side. I'm not saying that it's only on the first part who is executing, in the other side also. Applicable authorities, who are connected authorities. The law is one part of it. Suppose there is certain land, I'm just trying to say, there is a land which is as per the BMC, Municipal Corporation, it is coming under the reserved zone. If it is a reserved zone, when I say reserved, it may be reserved for the garden, it may be reserved for playground, it may be reserved for bus depot, or maybe reserved for railway station. Maybe there is a plan already made for road extension. So certain lands are going to be going there. So as a consultant, when we are talking about the drafting the agreement, we also need to look into what are the issues that is connected with those land parcel, those subject matter which I'm dealing with. Now, I'll just give you few more examples so that you will understand what I'm talking about. There are so many contracts which are executed between the promoter of a company and the investor. So they are called as a shareholders agreement. So if it's a private equity person or any investor, maybe it is a private limited company, it may be a public limited company. They invest based on certain promoters' obligations or rather promises. Now there has to be shareholders agreement. When we talk about shareholders agreement, the promoters and the investors will enter into a shareholders agreement. He becomes a shareholder. Having become a shareholder, then I am to look into what is the prevailing provisions for the Companies Act, whether the promoter has that right to do it, whether there is a provision which is there, the articles allows it. Is there a memorandum which has been submitted? Memorandum articles has that objectives, and then whether the money that has been given or invested, how I will be able to execute or exit from this one, what will be the return that I will get if there is a plan, let us say going to IPO, and if the IPO is not come, or if there is a exit through a initial investor through a private placement or private equity, some fund manager, some person is going to come, it has to be properly documented. And what will be the return? Will it be considered as a, some people may give a debenture. If it is a debenture, then whether there is a debenture trustees and whether it will be convertible debentures, which is non-convertible debentures, what will be the period for refund? So this way, various type of agreements are getting executed. And when as a chartered accountant, I always say that as a chartered accountant, our vision and our exposure into the commercial law is much more than an advocate. See, when I'm not here to compare the two professions, but at the same time, we need to understand that the commercial law, effect of the commercial law, whether it is a income tax, GST, or other applicable laws like development control promotions, or competition law, or company law, or partnership act, or LLP. These are the commercial laws which has various effect, whether it is a FEMA, whether it is a GST, income tax, all these commercial laws and economic laws. The knowledge that a chartered accountant and the which he has is much beyond what a normal advocate would have, because his area of limitation could be more of a stamp duty, registration, drafting, and maybe some related to litigation. The way chartered accountant have different verticals, that way also an advocate also have a different verticals of practice. Somebody practicing in criminal, somebody practices in documentation, somebody practices in company law matters, somebody practices in income tax, GST. So they also have a different area, and some practice in cooperative law, some practices in as I said, some practice in family court, some practice in civil court. So this way, the area of practice also differs. So therefore, when we are doing as a service to our client, we have to see that our drafting should be one of the best drafting. So if that is the case, then we should not hesitate, as our institute also always say, that subject matter expert should be involved. So if it is development agreement, a subject matter expert could be an architect. Subject matter could be a licensed surveyor. Subject matter expert could be an engineer. So subject matter expert could be, let us say, other promoters or estate agent who will give us certain valuation aspects, maybe a valuer. So this way, a subject matter experts. Now, in the case of a drafting of agreement, no doubt we have all the exposure related to the commercial law, but I would suggest that we also, once you draft the agreement, we should ensure to our client that please have it vetted with another person who will be able to discuss and decide with the some other matter. Give me 1 minute. Yeah. So therefore, it is also equally important that what happens is we have to see that the subject matter experts are used in the case of. Yeah, only 1 minute. Just hold on for a minute. Sorry, I had a urgent call. No problem. So coming to the next, as I was saying, that we should never and hesitate to get the subject matter experts for the sake of getting the contract drafted in a very nice manner. See, I may be drafting an agreement, but I'm also dealing with, let us say, about Singapore or a USA. I'm dealing with Australia. Then I need to look at the counterpart and what will the applicable laws over there and applicable laws here, so that I also do certain studies and then get the inputs, and then that can be incorporated. So here is a situation where if I'm not a practicing advocate, but I need to get it legally enforced, then I should not hesitate and tell them that better we involve an advocate. See, as a best practice that I would like to share what I am doing. Honestly speaking, when a matter comes, we are regularly into drafting. We are regularly into documentation. And it is not one type of documentation that we are doing. We are doing n number of documentation. So when we are doing all this n type of documentation, whether it is a joint development agreement, it's a purchase of the land, whether it is related to agreement for sale, it's a sale deed, conveyance deed, and various shareholders agreement, merger, acquisition, all these type of documents we do. But when we do this document, we always ensure that at least 2 or 3 other subject matters are involved. A conference is held, and then each of the points are noted down, and the junior drafts it, comes to us, and then we add it, and then this draft is shared internally with the client, internally with their team members, with our team members, and then we also have connected. As I said, there will be a joint meeting, and once everything is drafted, it may take about 15, 20 days or 30 days in getting a first draft. But this draft need to be improved. See, the drafting is again a skill. It's an art. I would not say that every draft is a good draft. Every day there is some scope for improvement, and we need to look at, as we are getting into a practice of drafting skill and drafting a contract. Then what we need to do is we need to apply our mind how the drafting can be improved. What is left out earlier, and is there any scope for improvement? And then the debate and discussion, and there has to be somebody who will be really posing as a respondent. I just would like to share you a small story which will also understand and make you a little coming to the situation that I'm talking about. See, one of the clients went to an advocate, and when he went to the advocate, and he explained that I have certain disputes related to the other side, and therefore tell me what is the recourse that I need to take, what is the available. Have you gone through the draft agreement? You have gone through everything? He said, yes, your agreement is good, everything is good, don't worry, you will have a winning side, and the law is on your side, everything is on your side, and therefore we will definitely file a case, and my quotation will be so much, and tomorrow itself you come, I will see that you get the justice, and you have a merit in the matter. After having 2 hours, 3 hour discussion, and again asking that advocate, are you sure that I have the best case? Are you sure this will happen like this? Are you sure this is the what? If the other side talks like this, what will happen? He started talking all negative, but still advocate was not ready to lose the client, and he said, no, you have a very good case. After all the discussion, after paying a consultation, he said, I'm sorry, I will not be able to pursue with you. He said, what is the problem? He said, the client said, I would have definitely given you a case if you had said that the other side has more case, because I was representing on the other side. See, the case is belonging to me, but I came to say that I am representing other side. Matlab, what I am trying to say is, as a devil's advocate, though he is the purchaser, he represented to the advocate as he is a vendor. He is a purchaser of a land, but he represents as if I'm the vendor of the land. And going as a vendor of the land, and he said, if this happens, that happens, will I go? So he said, yes, vendor has all the right. But whereas he's a purchaser. So therefore, sometimes some of the advocates, in order to get the clients, they also don't divulge or say so many things. And if you don't encourage and boost the client or inspire them or tell them certain commitment, they will not come to you. So these are sometimes known to the clients. So therefore, they come like that. Coming to the point of ours, what I'm saying is each of the clauses need to be debated, discussed, looked into from various angles. And that is where the experience comes. That is where the art comes. So that is where the improvement comes. So you may not, believe me, but as we draft every agreement, every sale transaction, every conveyance deed, every development agreement that we do, every time that we do, one or the other things we go on adding. Now, how can we go on adding? What happens is, in the process, we come to know that certain litigations have happened, this has happened, that has happened. So these litigations have given rise to this. So all these are captured, and that is how things gets improved. So now I am coming to the concluding part of drafting. In the conclusion, as I said, the very purpose is to get it enforceable. Now, if it is related to immoral property, that means applicable stamp duty has to be done. If I don't pay applicable stamp duty related to the immoral property, then that agreement becomes unenforceable. So in Maharashtra, we have Maharashtra Stamp Act 1958, where section 34 says, if the agreement is not sufficiently drafted or rather paid stamp duty, that becomes not having a legal status, it cannot be enforced. It cannot be considered even in the court of law, evidence in the court of law. If that is not going to be considered as evidence in law, then how can I get implemented? In that case, I will have to go to the stamp duty department, get it regularized, and then pay the penalty 2% per month, maybe 400 times, 400% of the penalty I will have to pay. That is huge amount. So therefore, the very important one has to see not only the drafting skill, you have to see how it can be made enforceable. If applicable stamp duty has to be paid, it has to be paid. Secondly, the documents, whether it's for a movable property or a immovable property, naturally we can always get it registered. However, if it's an immovable property, without going any further things, it has to be registered. So therefore, section 17 of the Registration Act 1908 says that any immovable property where the transactions are more than 100 rupees, and every immovable property transaction, 100 rupees of 1908. So you can imagine, and today we are in 2023. So after so many years, naturally, the value of 100 rupees must have been going, but the law has remained as it is. There's no amendment which has been carried out. So any immovable property having worth more than 100 rupees, that has to be in writing, it should be duly stamped, and it should be registered. So therefore, registration also is equally important. Somebody may say, what is the value that I get under the registration? See, what happens is, under the Registration Act, both the parties come before the registrar, admit their execution, they confirm with the two witnesses, and the witness KYC is taken. The executors, both the parties who are executing or more than two parties who are executing the contract, their identification is taken, their KYCs are taken, their photo, PAN card, Aadhaar card, everything is taken. Under the Registration Act also, there is an amendment that every person who is executing has to give a PAN card, he has to give the photo, he has to give the Aadhaar card. So it is linked with the Aadhaar. So therefore, this is another thing which need to be looked into, that registration has to be done. If the registration also under the Registration Act, it has to be done within a time-bound manner. That means within 4 months from the date of executing the agreement, it has to be registered. If it is not registered within 4 months, naturally next 4 months, you can pay penalty. Every one month, 2.5 times of the penalty will be levied. So in the first month delay, that means if you are registering in the 5th month, that means you have to pay the registration fees plus 2.5 times of the registration fee as a penalty. Then 6th month you are doing 5 times of the registration fee. And if you are going in the 3rd month delay, that means 7th month, 4th month, there is no problem. 5th month onwards, 2.5 times penalty of the registration fees goes on increasing. So after 8th month, yes, you will have to pay 10 times of the penalty. Suppose registration fee is 3,000, 30,000, you have to pay 3 lakh rupees as a penalty. So 3,30,000 as a registration. Now, having said that, after 8 months, you are not able to register the document. Now, if that document is not registerable, then how can you get it registered? Naturally, both the parties will have to enter into a new confirmation deed. They have to enter into a confirmation deed. They have to pay additional stamp duty, differential stamp duty. Come for registration. Then, as on today, we will have to go to the court. We have to go to the civil court and get the registration done, or rather, we have to go to the court, get the the court to appoint an executor and maybe enter into a certain type of litigation, and then everything is done. Parties will be called. Then, if the parties for some reason they are not executing, in that case, the court may direct to execute. So this way, the registration also need to be done as quickly as possible. It should not be kept pending. So therefore, when you are doing, there are normally, in a case of a immovable property, there can be 3 types of documents that normally is being done. Now you may say, what are the 3 types of documents? In an immovable property, I'm just talking because this can again vary to case basis. It can be more than 3 also. But let me tell you initially to start with, because in the drafting skill, we also need to look into what is the, suppose I am representing a vendor. I need to see everybody. When you are drafting for somebody, they are the people who are taking your service. Therefore, we have to look at the the benefits or the protection that I will be able to give my client. So if I am a vendor, naturally, unless until full money is issued, I may not be ready to execute the registration deed. I may not be ready to execute the conveyance deed. I am not ready to get the properties transferred in all respect in the other side. So therefore, initially, if it is a immovable property, development right, or a agreement for under construction property, naturally, minimum 3 types of document that we do, or maybe 4. See, when we do a token, we give a token amount, there will be a receipt for the token. And then it says that token is forfeited if there is no formal agreement is executed within next 15 days, 20 days, 1 month. So this is a simple token, earnest money. And then you are trying to like a, booking with the part payment that you are going to execute a detailed transaction. That's the first and foremost thing. The second very important thing that we need to look at, because I'm looking at the vendor, and vendor does not want all the right to be transferred. But there are certain obligations the vendor has to do, certain obligations purchaser has to do. And because there are certain obligations, let us say I have got, as a vendor, my client has got 3 people, out of which 2 are elders and 1 is a minor. And because he is a minor, I will not be able to execute any document, even though I'm his mother or a father, I'm a guardian, I'm looking after that minor's child, or a person who is mentally unsound, I'm not able to do it. So in that case, I need to appoint a guardian, I need to go to the court, I have to get a permission. So what we can do is, we can execute an MOU. So in the document and a contract, we enter into an MOU. So if we are entering into an MOU, naturally, that memorandum of understanding could be the second document. First, I said token amount, agreeing to sell, and certain amount is given. Nothing is written in that document other than saying that we have agreed to sell you subject to entering into a terms and conditions within so and so time, and otherwise your token amount of 1 lakh, 2 lakh, 5 lakh, whatever is given, earnest money will be forfeited, because that is a period where you are holding my property. You are not allowing me to sell. So therefore, that token earnest money receipt can be the first. Second, I'm talking about MOU, Memorandum of Understanding. Let us understand what is Memorandum of Understanding. Memorandum of Understanding is an understanding, is agreed upon, or certain things which each of the parties need to comply before entering into agreement for sale or entering into a formal contract. Now, will the Memorandum of Understanding give any rights to each other? The answer is no. Memorandum of Understanding is a agreement, or I would say memorandum of understanding, as the word itself says, is an understanding that has been arrived at without creating any rights on each other. So therefore, memorandum of understanding is normally executed between both the parties if there are certain obligation that is yet to be done. As I said, in my case, I am a vendor. I have got two people, that is two brothers, and I've got one minus brother, because of whom we too may take a interest, and we say, or we may be having our own mother who is also one of the parties, who takes as a guardian and says that no, the guardian also need to take a permission from the court before executing. So therefore, we enter into an MOU saying that yes, we agree to sell this land to you for a consideration, let us say 5 crores, and within next 6 months, or as the time permits, okay, we will be getting consent from the court. But all the terms or conditions are agreed upon, that is 5 crores, how the payments will be done, both the obligations are written, but no rights are created on each other. Suppose he is not able to get, let us within 6 months, the court permission to sell the property, then nothing can be done. Let us assume for a minute, I am entering into a trust property. I am a trustee of a trust. Naturally, I need to take Charity Commission's permission. Without the Charity Commission permission, I will not be able to sell that trust property because it is a public trust. Now, in order to get the Charity Commission permission, there will be certain procedure that will be entered into. Maybe it may take 2 years, 3 years. So, but the contract is made, understanding is made. Suppose the Charity Commission does not give the permission, what will be the consequences? The consequence is whatever the earnest money paid will be returned along with the interest of 6%, 10%, 12%, or how much money will be forfeited. Who is the defaulting? Now, let us say certain obligation or certain understanding is also on the other side. Other side, let us say a buyer, he says he is a chief promoter of a society. He says, I will bring about 100 people. I'll register a cooperating society. And now I am giving you 1% of the value that I have agreed upon as an earnest money. And tomorrow, if I'm not able to form a society within the next 6 months and take the title of the land, then my 1% you may forfeit. So now what he has done, he has formed a housing society where the people have been brought in, and that is how things have been done. I think you are able to make up your mind as to how an MOU is being executed. MOU drafting also is equally important, because as a consultant, we always need to ensure this is also a negotiation skill. It is also a drafting skill. It is a best practice that one has to adopt, that if there are certain things which are pending on either side, MOU is the best document that we need to enter into, and we should not be executing any type of agreement. The third document that normally is entered into, if both the parties are in a contracting capacity and they have got a capacity to enter into a contract as per the Contract Act 1872, in that case, then they can enter into agreement for sale. Now, when we do agreement for sale is executed if certain obligation on my side, because I am a contracting party, my subject matter is good, but I need to give certain compliance over a period of time, and certain consideration also comes over a period of time. Thereafter, I execute a conveyance deed. I enter into a sale deed. For example, the agreement for sale comes in a case of an under construction property. I'm a developer. I'm going to construct a land or construct a building and multi-story building, and I enter into certain terms and conditions that so much square feet of the flat is given to you on so and so floor. This is the approval that I will be getting. This is the occupation certificate. This is the completion certificate that I will obtain. And stage-wise, you have to make the payment. So everything is mentored, and of course, RERA is applicable. All this agreement for sale is made. and that is registered, stamp duty is also paid. The last is, once all the contracting terms, both the parties comply and completed, then there will be a sale deed. So I enter into a sale deed saying that as per the agreement for sale, which is registered on so and so date, all the compliance from your side is over, my compliance is over. Now the product is become final, completion of the building has been done. So therefore, I am handing over you the position of the premises. I'm handing over you the complete key, and then you have also make me a full payment, so the transaction becomes full and final. So this way, when we are negotiating, when we are doing a documentation, and we are entering into a contract, we also need to understand what type of documentation that need to be done. The first is earnest money receipt, acknowledgement for the amount received, and allowing and agreeing to sell a particular premises subject to the terms and conditions that need to be done within a particular period. Otherwise, the earnest money gets forfeited. Second is MOU, memorandum of understanding, where we are saying what will be the obligation that a first party would do, what will be the obligation that the other party would do. If there is a conferring party, what will be the obligation of a conferring party? I will also slowly explain you what is a conferring party, what are the terms and conditions that conferring party, and under which circumstances we need to get a conferring party or a third party in a particular contract. That also I will explain you a little later. The next, as I said, the first is a receipt, second is your MOU, third is an agreement for sale or agreement to perform certain things. The development agreement also can be considered something like an agreement for sale, performing certain things. And the last comes a conveyance deed, a final document after completing all the obligations on both the sides. Now, the very important question normally which is asked by either side, and especially by the vendor, that if certain obligations are not made by the purchaser or the other side of the party, then I should have a right to terminate. Excellent. Can a certain clauses of termination can be put? Now I'll tell you, none of the purchaser or a beneficiary of a contract would like to have the termination clause. If those termination clause is put, then the beneficiary of a contract always says, what is the use? I'll give you an example, then you will understand why people don't want a termination clause. I will give you a classic example. Let us say I'm a land vendor. I'm selling a land, or I'm a housing society, I'm a RWA, which I'm giving on a development right, joint development agreement with the promoter. Promoter has given me 10% of the considerations in form of cash or a check or in the RTGS. So I have issued that money. He also has said that additional 30% of the built-up area also will be given to me, which also he has reserved. And thereafter, he has started a construction of the building. And having constructed the building, 70% of the available flats, which is for him to sell in the open market, he has started selling and he has created the rights. But in a development agreement, if there is a clause that if he does not complete the building within a period of 3 years, the vendor will be able to terminate. Now, having terminated, then the other clauses you will mention that, yes, in that case, the vendor will forfeit this, will forfeit that, he will not get any right. Now, when it will be terminated, how will it be terminated, all that you will mention. Now, if you mention all this, the beneficiary is the developer. He would say, sir, you are writing everything about the termination. Fine. Then I'm not interested. Why I'm not interested? Because I invest crores of rupees, say 50 crores, 100 crores, and one day you terminate me, then I will get into a litigation and your property will be stuck, my property will be stuck. So I don't want a termination clause, and the agreement should be irrevocable development, irrevocable contract. So can such clauses be mentioned? The answer is yes. We can make a irrevocable development agreement. We can make a irrevocable contract. But does it mean that it is not revocable? The answer is it is revocable. Now, when it becomes irrevocable? So this is where the drafting skill comes into place. And that is how a smart draftsman or the consultant should put, or legal consultant should put his mind. The drafting should be in such a way, as I said in the beginning, that what are the duties that a vendor has to do? That is very important. And within what period he should do. If these things are not compliant, that means there is a breach of contract. Any breach of contract, you are other side, even if it's a irrevocable subject to compliance of the terms and condition. So you can always say the contract is being given subject to compliance of all the obligations casted on the promoter. So that means, or the developer, or maybe, purchase of a contract. So unless until the obligations are not fulfilled, then that irrevocable does not have the sanctity of irrevocable. Irrevocable subject to completing all the terms and conditions. So this way, though you are not having a terminology called termination, but if there are obligations are not fulfilled as agreed upon in the contract, naturally you are entitled to get it. You are entitled to get it terminated. So therefore, what I'm saying is, even if it is said that the contract is irrevocable, it can be revoked. It is not that contract cannot be revoked. Contract can certainly be revoked, and therefore, when you are representing let us say, even the vendor, even if the other side wants it to be revocable in the negotiation, and you can say irrevocable, but you have to see the terms and condition in such a way that if those are not complied, then you have a right to terminate. But though it is not written exclusively in your contract, but that has to be having a hidden meaning, and you will have that right because of the breach of contract. So you can always say any breach of the contract on the either side have the legal rights to enforce the contract. So therefore, when you talk about enforcement or take any decision, or that's, which means indirectly you have recorded that I have the legal right to take the necessary steps, legal recourse in the due process of law. What is the due process of law? Yes, you are not complied with the breach, so therefore I need to, terminate. Now there may be certain small contract where the mitigating is possible. If it is a small contract where the mitigation is possible and going to the court and other things becomes too complicated, then we can always have a clause, something like what will be the damages the other side will pay if there is a delay in the execution. For example, in a development agreement, what happens is the developer has to do within 3 years. Now, if he is not doing, and there are rent which you have agreed to pay in a period of 3 years, certain amount of rent for the transit accommodation to the existing people, and you are making it 4 years, then you can always say in the contract that till you give us the portion of the premises in the new building with completely, till such time you have to pay that. It also can have a clause that every month, every year, the rent will be increased by 10% of the previous month, so that you have put that in place. There can be a penalty clause. In case there are certain amount is payable by the purchaser which he has not paid, then you can always say that damages in the form of interest, compensation, 1% per month or part of the month will be taken. So this way, certain things can be crystallized. And if the contract is for any reason be, terminated, then we can always, instead of leaving it the court to decide about the damages that is to be paid by either party, we can get documented that the liquidated damage in this case will be 10% of the cost of the apartment, 10% of the cost of the land, 10% of the consideration amount. All this can be, I'm just saying 10%. One can mention the absolute figure also, that the contract, the liquidated damages could be so much. So therefore, we are not leaving it to the court or the authority or the arbitrator to decide about what will be the liquidated damages, but that also gets crystallized and recorded in the agreement or a contract. So this way, the contract should have this type of, things in the agreement. Now I will come to the last part of my documentation skill. The documentation, as I said, there can be certain confirming parties. Now, when we talk about a confirming party, now Who will be the conferring party? The conferring party is the person who confirms the transaction. Now, when this type of conferring party we do take, suppose I'm just giving an example that we have already agreed that the flat was or the land was belonging to my father. Now, father has expired. Now my mother is there. Mother has agreed to do the development agreement with the, let us say, promoter. Now, having agreed that promoter, then there was certain legal notice which was issued by, let us say, our uncle, saying that this flat or this land which your mother and rather my mother and all of us as a legal heir which was belonging to my father, now I am trying to sell, but the uncles said, no, it was though in your father's name, but this was a joint family property. It was nothing but a HUF property, which my grandfather had sold certain property, and being your father being eldest brother, it was shown in his name being a karta of the joint family. So therefore the property belongs to me. Now there are certain legal issues issued, and there are certain legal matters which are going in the court, and the matter is pending in the court. But at the same time, we would like to sell the property. The buyer is also interested. And in the process, instead of going to the court, having a consent term and all that, and we don't know what will happen. So the uncles who have taken the objection, who have filed the case, we can, even after having a consent term over there, because that consent term, everything happens, but they withdraw. And again, we may create a problem. So therefore, the uncles can come as a conferring party saying that certain consideration is paid to them. So now they are giving a NOC. All the history of the litigation can be recorded, and they also take an obligation that they will go there and withdraw the petition, and then all this will be resolved. So this way, there can be a conferring party. Now, another example I'll just give you so that we understand how the subject matter gets affected. Let us assume for a minute that I have given a flat on leave and license basis. It's a residential flat which I have given on leave and license basis, and my tenant is staying there. Now, I had taken huge deposit, say 25 lakhs from my tenant, and the properties are worth 1 crore. Now he was not paying me rent, and I am not able to pay the deposit also, refund the deposit. So therefore he is continuing. Now I have decided to sell that flat. Naturally, because I am selling a flat, the position of the flat is with the tenant. The tenant can be made a conferring party in my transaction, saying that 25 lakhs will be paid on my behalf to the tenant directly by the purchaser. And as and when it is paid, he will vacate the premises, he will hand over the keys so that his obligations are recorded, so his statements are recorded. And if he does not do it, I will be able to go in the competent court and get him evicted. So this way, the conferring parties at a different time can be done. As I was saying, that when we are entering into a immoral property transaction, applicability of income tax, other laws are equally important, because you know that 50C sections will be applicable if the stamp value is something more and I am entering into a lower value. Naturally, the differential will be unnecessarily taxed in both the hands under section 56 and as a differential value, and then I will be liable to pay penalty, income tax, and the other side also is liable to pay income tax and other things. And as I said, applicable law is equally important in various sections. Suppose my land is an agriculture land or a land which was belonging to collector, unless until I pay certain unearned income to the collector, there is a certain portion of the premium to the collector, I will not get the transfer right. But I am doing a transfer right through an MOU, and I undertake to pay certain amount to the collector of the district, who has given me the occupancy right of the land on which I want to do the development right. Then 50% or whatever the collector's provisions I will have to pay, and that only after paying that I will be able to comply. There are certain lease rights which are given. The lease rights also, I have got a lease land. Naturally, if there is a lease land, then I will have to enter into something called when I am transferring the lease rights. Naturally, I need to get a confirming party as a landowner so that he will also give a consent for my assigning the lease right to somebody else. If I don't get that consent, possibly that landowner may terminate the lease, and ultimately the beneficiary also will be into trouble. So with all this, what is that I want to drive today? Drafting is a skill. Knowing the subject matter, knowing the law, understanding the sentiment of the parties involved, and negotiation of each and every terms in the agreement is equally important. When we draft the agreement, we put it in the first place, looking at the person whom we are drafting. Normally, it's a beneficiary of the transaction. Let us say if there is a vendor and the buyer, it is a buyer who should draft the agreement. It is a buyer who should, on whose behalf we should draft the agreement. And the other side should be only vetting. If it is, let us assume for a minute, a vendor, in certain cases, it is a vendor's advocate who drafts the agreement. Possible. If that is done, the buyer's also advocate should be taken, or his legal consultant or a chartered accountant should look into the peripheral, and each of the terms should be negotiated in such a way that our clients' rights are fully protected. Now, I have limited time, and another 5 minutes, I will only tell you that what is the primary law? Contract Act. What is that Contract Act? What are the clauses in the Contract Act which need to be looked into? Thereafter, we have another 10-15 minutes for question answer. So to start with, let me take you directly to the Contract Act. There are various like Easement Act. I'm not getting into all that. I will straight away come to the Contract Act so that we are able to look into the required. So there are various, I'll straight away come to the Contract Act. Okay. See, Indian Contract Act, I'm not going to get into the background, but the Contract Act has, acts enacted originally had 266 sections. Now, even if there are Indian Contract Act, it's of course done by the British government, 1872, which is one of the oldest act, and it has still its relevance today. And it is still enforceable, and it is considered to be one of the best Contract Act, the least amendment that has happened. If you look at the Constitution of India, more than 100 amendments have already taken place, but in the Contract Act, there is no such amendment. That means you can understand the thought process that has gone in drafting this Contract Act. So, general principles of law of contract is section 3 to 75. Each of the sections that we are talking about, 3 to 75 general provisions, are equally important, because contract can be wideable, contract can be wide, contract can have not enforcing value. And what are the essentials of the contract? All this is given section 3 to 75. One has to look at these essentials. And accordingly, when we are entering into a contract, you have to see that all these essential principles are taken care. Now, contract relating to sale of goods was there originally from section 76 to 123, which has now been made as a Sale of Contract Act 1930. There is another contract, Sale of Goods Act for a movable goods, which has been taken. So immovable properties, and of course for movable properties also there is a Transfer of Property Act 1872. But here is the only for the goods which is there is Sale of Goods Act 1930, which is nothing but sections 76 to 123 carved out and made a new law. Now, when we talk about a law of contract, there are certain special contract which normally is executed, and each party's obligations are given. Now, what is the difference between a contract and law of contract, or the law that we are talking about? See, any contract cannot be contrary to the prevailing provisions of the law. The law will have a overriding effect, and therefore any conditions or any terms, condition that you put in a contract which is contrary to the provisions of the act is not going to be binding, and therefore the law will prevail and not that contract. So therefore, when we are entering into a contract, we need to see what are the provisions which are prevailing in the respective contract. So therefore, a capacity to contract, major person should be there. Minor cannot enter into contract. A mentally, mentally retarded person cannot enter into contract. So these are some of the important things. So Goods Act has been removed. Then special contract, indemnity, guarantee, bailment, pledge, agency. These are 124 to 238, which is still continuing in the Contract Act. And then contract relating to Partnership Act 1932 has been now made. That is section 239 to 266. So Contract Act which had got three different elements, four elements rather. Two elements have been retained in the Contract Act itself. Remaining have been carved out from the Indian Contract Act, and two different law has been enacted. So therefore, at present, Indian contract may be divided into two parts. One is dealing with the general principles of contract. Another is 124 to 238. Because whatever I have made in the red, which you can see, they are nothing but they are removed from here. So 1 to 75 is the general principles, and 124 to 38 to 38 is the special kinds of a contract, such as contract for indemnity and guarantee, contract for bailment, contract for agency. Now, I'm not getting into the various definitions. This will be shared with you. You will be available in any Google sheet. You can certainly look into. And I think in the intermediate also, you have studied about the Indian Contract Act, this being one of the economic law. But just to recap, is every agreement is a contract? No, every agreement is not a contract. Why every agreement is not a contract? As I said, the contract should have an enforceable value, but agreement need not have an enforceable value. For example, as I said, I'm having a contract with my son that he will attend my friend's marriage because I'm out of station. So I entered into agreement with him. It is an oral agreement, but with my son. But then he does not attend. Can I go to the court and say that, claim the damages? Not possible. So every agreement need not be a contract, but if it is a contract, agreement to become a contract must have given legal obligation, duty. There has to be legal obligation on both the parties. An agreement can be social obligation, as I said, and it is a legal obligation. If it is a social obligation, then an agreement giving rise to social obligation is not a contract. Let us say I have agreed with my friend that I will attend his let us say inauguration of his office, but I'm not able to do so. But that is not covered under the Indian Contract Act. So an agreement between two persons to go together to a cinema or a fora walk or for a dinner is an agreement of social nature, but not covered under the Indian Contract Act. I think now you are able to understand what I'm talking. Similarly, for example, I think you are able to see. Second is legal obligation, agreement giving rise to legal obligation covered under the Indian Contract. So there is a difference between an agreement and a contract. What is the difference? I have already discussed, and I think elements is an offer and acceptance in the agreement, but contract is a legally enforceable. So they are defined in a different things. Agreement is a wide one, and contract is a narrow because it has got certain things. It creates a legal obligation. Now, essence of a valid contract. What are the essence of a valid contract? Yes, section 10 says agreement has to be there, and to have agreement there has to be free consent. Both the parties. It cannot be by force. You make somebody to enter into a contract on a gunpoint. No, that is not, because there is an undue influence and blackmailing. Competency of the parties is very important. As I discussed, lawful consideration has to be there. It cannot be unlawful. For example, I enter into a contract with you that you will smuggle so much goods and give it to me, and I will pay so much. No, that is an illegal contract. Or I will say that you supply so and so persons, so and so girl. That is a human trafficking. So this becomes an illegal contract. So that contract, which is, or you go and kill so and so person, and I will pay you so much money. That's an illegal contract. So it's an unlawful contract. It's against the public policy. Anything which is against the public policy, against the prevailing law, is definitely, or you beat somebody and come and take me from me 10 lakh rupees. You cut his both the legs. So these are not the contract which you can make. They are not lawful, and there can be, these are lawful consideration. They are not each other. So legal object, there has to be legal object. It has to be lawful consideration. It has to be legal. And now the question arises, as we said, not given under section 10, but are essential of a valid contract. There has to be minimum two party intention to create a legal relationship, legal formally, certain meaning, possibility of performance. So now there are certain definitions which are given. There are two parties. There has to be offer, acceptance, lawful consideration. What are all these? Under which sections it has been given? Pre-consent means what? There should not be coercion, undue influence, fraud, misrepresentation, mistake of the facts. If there is a mistake of fact, mistake of law, there can be two: mistake of facts and mistake of law. For example, I have agreed to purchase a horse, but the other person thinks that I have agreed to purchase a horse after the death of the horse, dead horse. Because he had a dead horse, he thought I'm buying his dead horse. But actually, I wanted a horse which is having a life. So this way, sometimes mistake of facts can happen, and mistake of law can happen. Intention to create legal entity, all this is correct. And there are sections, as I said, these are the various sections one has to look into. I'm not going to deal with it in detail because now we are already 20 minutes, because already 1 hour, 40 minutes I have already taken. I have given you the negotiation skill. I have given you the best practices that you need to do. And then each clause need a lot of negotiation. So with this, over to the participants for your question answer. Thank you very much. If there are some questions, I will definitely take it. And this contract act, whatever we have done, it will be shared by the organizer, institute. Any specific question? Ruchi, you can ask participants if there are questions. Technical support, advocate Mayank. I have not seen any questions in the chat box. Any questions in the chat box? Should I conclude, Ruchi Chawla? Advocate Mayank?
Yes, sir.
So should I conclude, or is there any questions any participants have?
Any questions to anyone? If there are any question to sir? Sir, I think there are no questions.
Okay. So in that case, I will conclude in another 5 minutes as to the topic related to the best practices in the drafting. Is contract, so there is one question, is contract agreed between two parties over email considered valid in the court of law? The answer is 100% yes. Today, the courts also send the notices on the email. The parties who enter into certain contract on the email, as I said in the beginning, even if there is a oral contract, better to get it documented. Now, if I am sending some emails and the other party agrees on the email, whatever the terms and conditions that I'm sending, that means a contract is entered into. There's a valid offer, there's no enforcement, there is nothing. The other side also has confirmed, and that becomes valid. And then certain people, based on that, take the next course of action. And because they have taken the next course of action, the contract becomes valid contract. This can be considered as evidence. As I was saying, minutes of the meeting also should be sent on the email in the messaging, so that nobody can say that it is not. Now, there are various contracts which are electronically signed, digital signature. And today, the technology has gone up so much that many people, what they do is they pay the stamp duty electronically, they send the document electronically, and the digital sign is done, or on the email that is sent. Even those agreements are considered as valid document. The only thing, possibly, if the stamp duty is not paid, and it is applicability. In such case, the one will have to pay the stamp duty, get it the regularized, and thereafter it can be enforceable. So this way, the contract entered into on the email also can be considered as a valid contract. The next question which was asked, can you explain the important specific performance also drafting of contract? See, let us understand what is specific performance. See, we have a specific performance act 1963. Let us assume for a minute, what do you mean by specific performance? See, the vendor or the party of the first part says that I am going to complete so and so, so and so, so and so obligation. One of the obligation of the vendor is to get the property cleared, get the property completed, get the property handed over. And because of that, I have paid certain money to him. Let us assume 1 crore was the transaction for giving me a clear title of the land, and within 1 year or 2 years, he was supposed to clear the title and give it to me. Okay. Now you have agreed that within 1 year he will clear. Now the value of the property has gone to 10 times. So 1 crore transaction in 2 years, it has become 10 crores. Now what happens? He now says that I'm not going to hand over whatever money you have given me. Out of 1 crore, you have paid me 50 lakhs. I'm going to return you 50 lakhs. And if you want compensation, take 2% per month. Still, it becomes hardly, 48%. So that means 1 crore you have, out of 1 crore you have given 50 lakhs, another 50% I will give you extra for 2 years. So you get 75 lakhs. Whereas the value of the property has now gone to 10 crore. Now you can go to the court saying that, no, this is a specific performance which I want. That means you are going to the court of the civil court saying that what he has agreed upon, he has to perform and he cannot go back because based on that, certain things I have done. So therefore, there has to be specific performance. So the contract, okay, in the drafting of the contract, we have to see what is to be done. For example, I'll tell you one more thing. Now, in the contract, we say that the leave and license will have a blocking period. What does it mean by blocking period? That means for next 2 years, neither party can terminate. But in some times, what happens is the one who has given on rent, he may require it urgently, for example, and he wants to terminate. The question becomes, no, there has to be specific performance which has been agreed upon that he has to be there for, give us for 2 years. It is also possible that you have entered into for 2 years because vendor said 2 years you have to minimum take, you have agreed upon. But in the after 2 months, what happened is you have got the transfer to another place. Now you want to terminate the leave and license agreement, but there is a lock-in period of 2 years, and you are not paying the rent for 2 years because you are saying I am going out. You have a deposit of only 3 months. Now the vendor has finding it difficult. Then he can say that there has to be specific performance that the agreed rent for 2 years he has to pay. Now there is a question: what is the difference? Okay, so before that, sir, can trust deed be revoked by the creator of the trust during his lifetime? The answer is, what is the trust deed? Trust deed is you have created a trust as a settler. Now, having created the trust, you have created the trustees. You have created the beneficiaries. Now, having created a beneficiary, having created trust, if that trust deed has a clause that you can revoke, yes, you can do. If the trust deed has a clause that you can change the trustees, you can change the beneficiary, yes, you can do. So it all depends on how a settler or a trust deed is prepared. How that creator means settler. How the creator or a settler puts the terms and conditions, because ultimately it is your money, your trust, you are creating it. So therefore, how the successor of the trustees should be there, who will be the trustees for the lifetime, who will be the beneficiary, how you can terminate, all this will become a part of the trust. So if you are writing that the trust also can be revoked by the settler during the lifetime, yes, it is possible to revoke. The next question is, what is the difference between a void and voidable agreement? See, the agreement can be void and voidable. What do you mean by void? Void means if the essentials of the contract is not met, they are void contract, void ab initio. For example, as I said, I am entering into a contract for an unlawful object. What is unlawful object? I am giving a contract to somebody to go and kill and then take 1 crore from me. This is against the public policy, against the government, against the law. So that means the contract which is against the law is not enforceable. So it is void ab initio. Unlawful consideration, unlawful object, or unlawful party. Section 11 of the what we discussed just now, section 10, which is giving the essentials of the contract. And if those essentials are not met, they are void ab initio. A minor entering into a contract to perform certain things, because minor does not have a capacity to contract. So therefore, that becomes a void contract. Now, what is that voidable agreement? Voidable agreement means at the option of the other side, and he mitigates those defects, then those contracts becomes voidable. That means it is up to the other side to either terminate or consider it as a void or allow it to be continued. I'll give you an example so that you will understand. Suppose I enter as a contract. Okay. Now I have executed a contract as a guardian for a minor. Fine. As a guardian, I have entered, and then I have given it to the beneficiary. Now, actually, if the beneficiary wants, now though the contract is, which is called as an irregular contract. Now he can say that though you are entered into contract, now get the court permission, regularize the contract. If I don't regularize, of course, it becomes a void. But the other side gives me an option that please get the court permission, let us regularize the contract. In that case, at the option of the beneficiary, it is voidable. So that is what is called the contract, which can be, though it's a void contract, but there is an option to get it regularized, and other party gives you an option to regularize. Such contracts are called voidable agreements. Now, that's contract. I'm not talking about agreement, because agreement is a wide connotation. Agreement is something which may not be legally enforceable. We are on the contract. Now, registration of partnership deed, can it be done at a later years? Yes, 100%. See, let us understand very important thing. Any contract which we are doing, as I was saying, even if there are certain defects, in due course of time, those defects can be regularized. You are not paid the stamp duty. You pay the stamp duty, get it regularized. You are not registered the document. You get it registered. Similarly, partnership deed which is supposed to be registered at a particular time, and you are not done under the Partnership Act by paying certain penalties. In Maharashtra, we have 2,000 rupees per annum as a penalty for delayed registration. So we can pay the delayed registration, 2,000 rupees per annum, and then complying with the certain norms, we will be able to regularize the registration of partnership deed, whether by admission of the partner or retirement of the partner, everything. So it is possible. There's no problem. And once you regularize it, then it becomes enforceable. So even if you have got an agreement, let us assume for a partnership agreement, which is executed 25 years back, but you are not registered. But now you want to get it enforced. Certain contract you have entered into that partnership firm, and because you are not registered, you cannot file a suit and you cannot get recovery. Then now you have decided, the partners, that let us regularize those 25 years. So I pay 50,000 rupees as a penalty, 2,000 rupees per annum, 25 years, 50,000 penalty I pay. I get it regularized. I get it registered. Once I register with a backdated effect, then I can certainly go and get the court case I can file and get it regulated. Now the next question is, any specific author book on drafting and agreements for practicing CA? There are a number of books. I don't want to specify any book, but maybe because you have asked the question, and that too for a practicing chartered accountant, I would recommend and request the committees on commercial law, economic advisory, and co-produce and NPO to come out with a book, because there are so many guidance notes, guidance books have been issued by this. One of the book issued or published by them in RERA is certification, audit, and all. And now also we are coming out with certain things. So as an institute, I don't think we have come out with any book, but there are n number of books. Avatar Singh. There are various, even if you are able to look into the, of course, study notes and all of intermediate, that also gives you a lot of insights. But if you want a specific book on drafting of a contract, I think we will have to request the institute. Maybe they can come out with a very good book, and it will be a great asset and a great resource material for the chartered accountant. Certainly, we will look into. Regarding first question, if there are other side does not acknowledge or respond back over email, what should we understand? See, the question is very simple. That when you send an email with what you have agreed upon, what you are on the phone or on the email, or rather on the physical meeting or orally what is agreed, you are getting it documented. And you are writing one line there. So if any denial or if anything is there, please revert back within 15 days. Otherwise, we assume that you are agreeing with this. See, if there is no denial within the time-bound manner, maybe 1 month, 2 months, 3 months, but he denies only when you dispute in the court of law, then those denial will not be considered by the court of law because you had a sufficient time to deny. And it is not that you are not received. You have a genuine email, there is a genuine email address. You cannot say that I have not seen email and this was not known to me and now it has come to me as a surprise. That will not be accepted with the court of law. So if there is no denial within a certain time frame, it will be considered as the proper thing. So therefore, even if they don't respond, you can always go on giving reminders. See, if you does not remind within, so you can always give first reminder. I have said you are not reverted, so can I consider it to be confirmed by you? Still you revert it if you think so. 2-3 email reminder can be sent. And then many times what happens if you are buying a flat, the CRM people in a company, they go on changing. They don't understand and they don't respond to their mails. I understand. It happens in a big companies. And by responding, they don't want to confirm certain things. Since they are not denied, it means it is accepted. And so therefore you can go ahead. Now there is another question. Can undated agreement shall be considered as a void without giving any legal rights to both the parties? No, if the agreement is undated, you can always date it. One. Now, even if it is undated, that is the curation which can be done. And if both the parties have signed, sealed, exchanged, only date has remained, then even you can take a stamp paper or the stamp duty when you have paid, that can be taken as a date. So those are cannot be the reason, because this is something which can be rectified, and one cannot take the undue advantage of their own mistake. For example, buyer by mistake has not signed, thinking that seller will do. Now seller, based on that, cannot take an undue advantage because the agreement has no date. So therefore, either party should have done, but they have not done it. So this can be rectified, and we can identify the date. We can assume when was, because based on that contract, certain transaction must have happened. There is an exchange of money, there is an exchange of transaction, there is exchange of goods, certain thing must have happened. So collaboratory evidence, that is the way where the evidence act comes into picture. That is where the affidavit comes into picture. You can always say, sign an affidavit that on so and so date, this agreement was done, but by inadvertently, the date was not mentioned. So therefore, it does not become illegal. Is contract required to be registered? Yes. As I said, every contract need not be registered. Okay. But immovable property contract has to be registered, because Registration Act also gives certain things not required to be registered. For example, will, that need not be registered. If it is related to a movable goods, Sale of Goods Act, those contract need not be registered. So why it not be registered? Because Sale of goods, once you deliver the goods, receive the money, even if you give an invoice is also contract. Sometimes people do work contract. Works contract they can make on a plain paper, letterhead. So many MOUs are done on a plain paper. So therefore, they are not registered. So for movable, there's no such requirement as it should be registered. But for immovable property, anything above 100 rupees, whether it's a release deed, gift deed, transfer deed, exchange deed, sales certificate, or creation of a trust of immovable property, or mortgage deed, all this compulsory requires to be registered. So if it is not registered under the Registration Act, there is no validity, and implementing of that becomes more difficult. I'm not saying that it cannot be enforced. Then you'll have to give the reason why it was not registered, and who is the person who has not joined hands for registration. You have sent an email to a lot of emails to the builder, and the builder has not come and registered because after receiving money and he has defaulted. So in that case, the inconvenience is caused to the beneficiary. In that case, the court will take cognizance. However, yes, as I said, even if it is not registered, certain contract registration is a must for immovable property. If it is not registered, the collaborative evidence will be taken, and who is the person who has not joined hands for registration. But it is a long-term process. But if it is registered, it becomes much easier. If the contract agreement to sell is half typed and half handwritten, can it be treated as unenforceable? No, the answer is no. So long as the contract is half written, half handwritten, possible. And if both the parties have signed the contract and all the pages it has been signed, certain agreement we have seen that certain blanks are written. There is a pre-printed agreement like loan agreement, leave and license agreement, buyer and seller's names are entered, dates are entered, consideration is entered. But whenever there is a blank or handwritten, what you do is you put a counter signature on that. Both the parties sign saying that this is the additional document or the information which has been filled. So in that case, it is possible. So there are pre-printed agreement like leave and license agreement, and certain contracts are like even builder's agreement, loan agreement. They're all pre-printed where the names of the parties are written, consideration is written, time is written, and people sign. Because name of the builder is right, subject matters are right, terms and conditions are already predetermined. So only buyer's name, consideration amount, date of position is required to be done. The rest of the things are uniform. In that case, they are written by hand, and then each blank that you fill up or wherever you are written by hand, you need to say that these are the part of the contract. Sir, can the settler of the trust change the clause irrevocable at the time of creation of revocable to a revocable later? See, as I said, if he has written that it is a irrevocable, then where is the question? See, at the time of the initiation of the trust itself, he has to decide. However, the trustees can come to figure, and the trustees, if this is the trustees who have to take a decision, and it's a private trust, and the beneficiaries coming together, they can revoke later. For example, I'll just give you some examples so you understand. Let us say I've got a private property of, let us say 100 crore, a land, and I, being a settler, I have created a trust. Who are the beneficiary? My two sons are the beneficiary. I have created trustees. Who are the trustees? My wife is a trustee, and let us say my uncle, another uncle is a trustee. Beneficiary I have not made a trustees. Now these are the two people, because my children, they have to take care, and this properties, rent, everything comes, should be beneficiary for this. Now what happens? Now the trustees, both the trustees are there, beneficiaries are there. Now settler is also available. Now it is said irrevocable. Even after saying irrevocable, now those two trustees, because now it is for me irrevocable, but the trustees can take a decision. Now the trustees and the beneficiaries have come together saying that now let us dissolve this trust, and whatever 100 crore properties, there are 5 properties belonging. So
Sir, sir, sorry to interrupt, but the link might expire soon. So sorry to interrupt, but link might expire soon. So sorry to interrupt, but link might expire soon.
Not an issue. My question and answers are over, and time is also over. So thank you very much. I think whatever questions have come, I have answered. I extend my sincere gratitude to Committee on Commercial Laws, Economic Advisory, and Cooperative NPO cooperatives, and also Ruchi Chawla for introducing me and being a part of the moderator of this program. Thank you each of the participants for raising valid questions, and I hope I could do some justice to the topic given to me. Thank you very much. Thank you.
Thank you, sir. Thank you. I would like to thank you on behalf of CCLEEA and NPO committee and all the members. I am glad that I express my vote of thanks to you. I really thank you for accepting our invitation in the last moment and being there for us today. Your knowledge has truly inspired us. Thank you so much, sir.
Okay, good day.
Thank you so much, sir. Thank you.